Number 76 on the calendar, People v. Leroy Carver.
Good afternoon. May I please have 3 minutes for rebuttal?
Certainly.
May it please the Court, Janet Soames on behalf of Leroy Carver. Among the most significant of the errors by counsel in this case is his failure to move for suppression of key evidence taken from Mr. Carver's pockets and his person after what the trial record shows was an unlawful arrest.
Would that have helped him with the evidence that was found in the vehicle?
Would that? I think what we have is we have two things. We have the search of him after the arrest, and then we have the evidence in the vehicle.
We do, but if he had succeeded theoretically in having the items found on his person suppressed, would that have helped him in any way with the items in the vehicle?
I think at trial it would have helped him, but I can't say that it would help him.
How would that have helped him?
Because the items that were taken from the camera and the Avon lip balm were items that were taken specifically and directly from him. That was the direct link to Mr. Carver in the burglary.
But if you believe his story, it was no more connected to him than the other things in the vehicle.
Well, I think that when you put it that way, if you believed his story, having those items on his person, that gave an additional hurdle that he had to clear with the jury. They had to not only believe that he wasn't in the car or that he wasn't there, but he had to explain away this really devastating evidence that was found in his pocket.
And that undermining his defense, his version of what occurred.
Yes.
Counsel,
yes, exactly.
And just to Judge Stein's point, there seemed to be some confusion at the appellate division over what your argument was, whether it was failure to make a motion to contest the legality of the vehicle stop that Judge Stein was talking about, or was it the stop, the frisk, and the personal items recovered? So what is the position here?
Our position below was that the attorney was ineffective for not making a suppression motion. What I did was I took the strongest argument, I thought, which was the unlawful arrest, and really focused on that. What the dissent then saw, they saw my argument globally, and that is what I'm arguing here today. The arrest part of it, the unlawful arrest, I think on this trial record, it's not a close issue. I think it's indisputable that this was an unlawful arrest.
So to go back, you are arguing ineffective for failure to move to suppress based on a vehicle stop?
Yes, absolutely.
Okay, so what in this record indicates that anything was amiss with respect to the vehicle stop? I mean, for example, in another case we had, there was an inventory saying there was no crack in the windshield or not noting it. Is there anything here that would indicate that there was a reason that this stop would be suspect?
Absolutely. There's a colorable basis on this record to show that a suppression motion should have been asked for and would have been granted. What we have was the officer had testified that he was in a parking lot, and he was on the road, and when a car came out of the parking lot, and came out of the parking lot in the dark, and it is actually in back of him. He then pulls over and lets the car go around him, and then he follows the car for almost a mile. During that time, it's dark and the cars are moving, and it seems to me that there is a good basis to really challenge, did the officer see what he contended that he saw? Also, there's a basis to look at what the officer actually testified to at the trial. He said that there was a sticker on the windshield and that there was something hanging from the rearview mirror.
But is there any evidence that that wasn't the case, that there wasn't a sticker on the windshield and that there was nothing hanging from the
No,
mirror?
because we didn't have a hearing, and that would not have been the focus of the trial. That would have been the focus of a hearing. But when you look at what the officer said, he said that these things were hanging there. That's not a vehicle and traffic violation unless there's a little bit more about what's hanging there. First of all, it has to be obscuring the view of the driver, and then there's also stickers can be on the windshield in certain places. So we don't have any of that. We just have the officer's conclusory belief that there may have been a vehicle and traffic violation. We don't have specifics that show that it was. It's not like the cracked windshield in the last case where, yes, it's a cracked windshield or it's not. Here, he did not give enough information to really be able to determine. But I would point you to page 587 of the record. 587 of the record is a photograph, People's Exhibit Number 1, which shows the car. And the car, that photograph, it shows a little something hanging from the rear view mirror maybe, but it doesn't show any of the stickers. It doesn't show anything else. So I think on this record, we can't conclude that the officer was correct when he says he stopped for a vehicle and traffic violation, because we don't know that the drivers, from his perspective, that his view was obstructed.
So then going to the stop, the officer could make an investigatory stop, right? You don't have to have probable cause to arrest. Let's say he makes an investigatory stop, does a pat down, finds these items. What in the record indicates, I mean, he sees these items in the car, I mean, assuming the stop is okay. He sees the items in the car, they're acting very nervously, they give him a false name, they give him a false story about they were, and one guy takes off with a bag. And this door is open when he goes there and the seatbelt's off on your client's side of the car. What is there any indication he didn't have the basis at that point to do a stop and frisk?
Because at that point, first of all, he had no report of a crime whatsoever. He knows that the driver has just fled, and the driver could flee for a bunch of reasons.
But let's say he's covered in blood, but you don't have a report of a murder.
And there was a case, and I can't remember what that case was, but we don't have that, because that was kind of, this is an exigency. You know, there is something going on here, and somebody might be, and we don't have that.
Like a bag full of stuff with gloves on top and somebody taking off from the car.
That's not probable cause to arrest, and what we had here was...
Is it enough to be able to stop him and take him in for an investigatory
No,
stop?
no, it's not, because what we know from People versus Battaglia is that you cannot look at, some things that might be kind of suspicious, or just a messy car. We can't look at that and then hold the defendant, arrest him, hold him while you go off and look for a crime. Here what we had almost an hour between the time of the traffic stop and when the burglary was actually discovered by the homeowner. So under Battaglia, this is so far outside the bounds of what this court has held.
So given all these facts in this case, the officer should have let him go.
I'm not saying the officer should have let him go. I'm saying that there was enough on this trial record to show an unlawful arrest, and that should have resulted in a suppression motion being made by counsel.
He says the coat's not his, nothing in the coat is his. Why does he have standing to argue about this?
Because it's a fruit of an unlawful arrest. If you look at, and then to go back to Hicks, I just wanted to kind of clarify that in Hicks, that was an investigatory detention, which was lawful, where they knew a crime had occurred. They knew the witnesses were right around the corner, and they could dispel or confirm their suspicion quickly. We don't have any of that. What we've got is Mr. Carver being handcuffed, put in the back of the police car, and sitting there, and then taken to the station while we still don't have a crime.
Another question. If he was successful in suppressing the coat and its contents, couldn't the people have used that to impeach him if he testified?
I don't believe so. I think that possibly his testimony could have opened the door to that, but I don't believe that it could have been otherwise
if his
used.
testimony is as it was, and it appears to be the only real defense he could mount, was, I didn't know what was going on. I just woke up and, there I was. Then why wouldn't that open the door to saying, well, gee, we're wearing the coat, and it had the camera and the lip balm in it.
I think when you look at, I think it's U.S. versus Havens, Supreme Court case, where this issue was decided, and what the Supreme Court did in that case was they really looked at what the testimony was, and the testimony had to be pretty specific to find that the door had been open. And I don't think that with such general denial of I woke up in the car, I don't know what happens, I don't think it gets to that point.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors. Scott Miles for the People. The defendant in this case did receive meaningful representation, and although defense counsel did make some errors, his representation did not fall below the standard of reasonable competence. The suppression motion in this case had little to no chance of success. Therefore, the defense counsel is
Why is that? What was the reason for stopping the car?
Your Honor, based on the very little amount that is in the record, there is nothing in the record to indicate that there would have been any grounds for challenging the actual stop of the vehicle.
Do you know why he stopped him?
He's testified that he saw an object, a sticker in the windshield, and also an object hanging from the rearview mirror
Kind of like a
obstructing.
pretextual stop to you?
Potentially, Your Honor, but
So if it was potentially, wouldn't it be a good idea to maybe bring a motion and see if the court would agree?
if possibly, Your Honor, but that's not the standard that we need to look at. The standard is whether or not that motion would have had a chance of success.
Well, and as Soam says, you know, the whatever was hanging was inconsequential and the sticker was not within the range of the driver, it gets suppressed, right?
It, again, the testimony of the officer gives no indication that that would have been the case, that it would have resulted in suppression.
Is that the standard that this court has articulated, counsel, little chance of success, or is it that there has to be a colorable claim?
Well, the standard is that an attorney is not ineffective if the motion would have had little to no chance of success. It's in this case, at least as it applies to this case, the distinction between that and whether or not it's a colorable claim is really a distinction without a difference. In this case, the suppression motion would not have had, or excuse me, would have had little to no chance of success. Therefore, the failure.
Why is that?
I'm sorry, Your Honor?
Why would it have little or no chance of success?
Because based on the information that is in the record, the stop was a lawful stop.
In what sense? Was there testimony as to the size of the thing that was dangling and where the sticker was?
There was not, but there was testimony that there were objects obscuring the driver's view, and that that would constitute a violation of the vehicle.
I just think that ought to be challenged. I'm not judging this case right now. You know, we've had so many seatbelt violation stops, you know, and I always, which is fine. But I mean, then all kinds of things are found in cars, and I get that. And then someone's got a rosary hanging from their rearview mirror, and that's okay to stop. You can stop somebody for that. And I don't know. It just seems to me at some point there ought to be somebody challenging this stuff and saying it's not obstructing the driver. Stop doing this. And this may have been the case, that's all.
Potentially, Your Honor. But I would also note, Your Honor, that that argument was essentially unargued at the Fourth Department. The appellant's argument at the Fourth Department focused almost exclusively on the property that was found as a result of the detention and the search of the defendant. And as was thoroughly argued in that case at the court below, the property that was recovered was not recovered as a result of an arrest. It was simply a detention. And based on the facts as they were...
Don't you think they had a pretty good argument that it was arrest? I mean, he testified that they ordered him out of the car at gunpoint, that, you know, that he was handcuffed, he was put into the police car, and then there was testimony that the other officer was writing up what they would normally write up after an arrest. I mean, that's some evidence, isn't it?
There was testimony about the prisoner data report that was being collected in the car, but the testimony as to when that occurred was not clear. And again, we have that officer who was taking the prisoner data report did testify that there was a number of things that were going on in the investigation prior to him doing that. There was the search for the driver of the vehicle who had fled. There was the tow of the vehicle. There were a number of things going on. And at some point during that, there was the 911 call from the homeowner reporting that a crime had occurred.
When he gets stopped for the VTL, supposed VTL violation, he's the passenger, could he walk away? He's not the driver, it's not his car. Could he walk away?
At the point that he was stopped?
Car stopped, yeah.
Without any other information, potentially.
Correct.
Potentially, yes. However, that's not what occurred. What did occur prior to him, prior to the driver fleeing, was both the defendant and the driver gave what the officer knew was false statements. They lied to him regarding where they were coming from and what they had been doing. They gave false names. The officer...
And then that's connected to the VTL violation how? With respect to him as the passenger.
Well, it's leading the officer to a reasonable suspicion that the defendant was involved in a crime.
If that was true, and then they pulled a gun, put him in the back of the car in handcuffs, when were they going to arrest him?
When they knew that a crime had in fact occurred. When
So
that,
he hadn't been arrested, at that point, he was free to leave. He could say, take these handcuffs off, I've got to go to a meeting.
he was not free to leave at that point, Your Honor. He was being detained. He was being detained so the officer could further his investigation.
Well, how long could they detain him? This was about an hour, I think, before there was a report of a crime. Could they have detained him for more than an hour, less than an hour? How long could they detain him before we would consider, or you would consider that an arrest?
That is not clear. I think more than an hour is a reasonable amount of time.
If it's unclear,
Given-
should there have been a motion of some sort, maybe addressed to that issue?
Again, Your Honor, we have to look at whether or not that motion would have had any chance of success.
Sounds like you're saying it may have been.
Well,
We don't know the answer to a lot of questions.
What I was going to say, Your Honor, is that I don't think an hour would fall within any risky amount of time. And again,
You say more than an hour.
I would say more than I think you would have to look at the specific facts and circumstances in each individual case. And in this case, the officer had a great deal of suspicion that a crime had been committed.
Well, what's the crime he as the passenger is committing? What's the suspicion about his possible criminal act?
That he had the same connection as the driver to the property that was in the car.
That's just, I'm the cop, I looked in the back of the car, the driver and the passenger have given me wrong information about their names, they're a little bit nervous and agitated, the driver just ran out, that's enough for me to stop the passenger at that point.
Well, again, Your Honor, the driver did run away, and when the officer got back to the car, in his view, the passenger was in the process of also attempting to run. His seatbelt was off, he was in the process of opening the door. He was in the process of attempting to flee, just like the driver had. So at that point, both the driver and the passenger have equal culpability as far as the property that's
So
in the
if the
car.
driver had lied and the defendant, the passenger, refused to answer, could he have gotten up and walked away? Or is there now suspicion also? He refuses to answer. He has a right not to answer you.
Refuses to answer the officer as to who he is.
Correct.
Again, at the point that the officer looks in the car and sees the property, sees the screwdriver, the gloves, the other property, I think at that point,
Assumes it's not theirs because they've lied? Is that why? People never
given,
put things in the back seat?
given the location of the vehicle, the time of day, the other property that he sees, the gloves, the screwdriver, the items that
Where's the screwdriver?
I'm sorry, Your Honor?
Where's the screwdriver?
I believe the screwdriver was, I apologize, I believe the screwdriver wasn't found until after the defendant
okay.
was detained. I believe it was in the front seat by his feet. But the duffel bag with the gloves and the laptop were in plain view, and again, given the time of day and the location, the officer was reasonable in his further inquiries. And at the point that he did take the defendant, that he did detain the defendant, whether or not the detention at some point would have become a de facto arrest without the 911 call reporting the actual crime, the property that was recovered from the defendant was recovered immediately. It was recovered as soon as he was taken out of the car and the officer frisked the
But
defendant.
it looks like there was, there was some suspicion of a crime and you were looking for a suspect or something to attach to a crime. So you were waiting for a crime to happen.
I think actually, Your Honor, the opposite is true, is that they had a suspect and they were looking for the crime.
That's what I'm saying, you're looking for a crime.
Yes, the officer was trying to determine what this situation was and what was going on. And given the circumstances, given the fact that the defendant had lied to him, had no identification, had in fact given him a false name, it would have been unreasonable for the officer, given that the facts as he knew them, to simply let the defendant walk away.
Because he has a duffel bag and a laptop in the back seat of the car, it's not his.
And had lied to the officer and was attempting to flee.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
Thank you. In People versus Ryan, this court said 13 minutes was too long for a lawful investigatory detention. Here we have far more
Counsel-
time, and we have
Counsel, I'm sorry,
circumstances.
excuse me. On that point on how long, right, isn't the issue here the pat-down? So if they can stop this defendant and pat him down and they find this, isn't how long they detain him, doesn't that go to whether he makes statements or what happens subsequent to that? Why would the length of detention after a lawful pat-down search affect that?
I guess I would disagree that it was a lawful pat-down search right away.
But the timing, though, okay, assume we can argue lawful or not, but don't you go by what the facts are at the time that's done? How would how long he's detained after affect the legality of the pat-down?
Because I think when you look at what happened here in total, it's an unlawful arrest from the very beginning. The officer said that when he took him into custody, he pat-frisked him. He said that the minute he was starting to open the door, he ordered him out of the car, and at that point, he secured him. So what we've got is a full-blown arrest right from the minute that Mr. Carver was ordered out of the car. The officer didn't pat-frisk him first and then kind of, talk about things and eventually decide he was going to handcuff him and throw him in the back of the car. This was a full-blown arrest right from the beginning. Hicks is permissible, investigatory detention is permissible because it is so quick to confirm or dispel suspicion, and it is minimal intrusion. Here we had the maximum intrusion. Hicks, you had the defendant was allowed to park his car. The defendant was told, you know what, if these people don't identify you, you're going to be released, and so there was an expectation of release. So Hicks, there wasn't an arrest by any means. Here, this was a full-blown arrest, and so this is far outside the circumstances of Hicks. And I would just like to point out or respond to one of Judge Piggott's questions. This is an adversarial process, and my client is entitled to challenge the evidence. If we're in a position where every time the police say, geez, I stopped him for a V&T because, I thought he was going too fast, and, does that take the ability to challenge the evidence away from the defendant? And here what we had clearly, this record shows that there was a basis to make the motion, and I don't think that, we have to show that we would win the motion, but there was certainly a basis to make it, and if the attorney here had made the motion, we're not sure what would happen, and that's why I think in Bellel, what we've got is, I was waiting for the Bellel decision to come out because I thought maybe that would give me a little bit of guidance here. But I think what the court in Bellel did was it recognized that without a hearing, we don't know.
Yeah, but
and
in
there's a
Bellel,
lot.
the officer's testimony, there was something on the record that cast doubt as to, what the circumstances were. Here, there's just nothing on the record that would cast any doubt to the legality of the stop.
I think that when you look at the photograph, and there's an argument that could have been made here, and I think when you look at the photograph, you consider that this was in the dark, we shouldn't always have to just take the officer's word for that, especially here when his word doesn't exactly constitute a vehicle and traffic violation. And just one, if I could just mention the sentencing here, my client had years of his life on the line, and the attorney did not say anything on his behalf. He basically said, Judge, you heard the evidence, and you know where we stood on it.
Thank you, counsel.